Don, welcome back to Conduct Detrimental. It has been a minute.
It's been a minute or two. Yeah. Good to see you, Dan.
Good to see you as well. So let's jump right into it. And listeners of our show are certainly watching this opinion, and I was very, I wasn't surprised, but I was very happy that you dove in on this. So, I think analysis of this Gruden decision requires some callback to why we were here in the first place, why we were involved with Dan Snyder and the Washington Commanders, and the fruit of this case is really these leaked emails, these inappropriate comments. So I think in order to tell the true ramifications and fallout of this Nevada Supreme Court decision, I think we should start with a retelling of how Gruden ended up in court in the first instance. And Donna, I think you're reporting maybe better than anybody in the country. You've been there on ground one with Snyder, so I think you're the right person to at least give your perspective on it.
Well, I appreciate you saying that, Dan. Yeah, it all began with the Dan Snyder investigation that was conducted by a Washington lawyer by the name of Beth Wilkinson. And if you remember, this was an inquiry into allegations of toxic workplace culture at the Washington Commanders, directly related to Dan Snyder. There was sexual harassment allegations leveled against an owner. And so Beth Wilkinson conducted this investigation on behalf of the National Football League. It was actually an investigation that Snyder and his lawyers had a joint sharing agreement with whatever evidence came out of it. And in the course of doing that, Beth Wilkinson obtained 650,000 emails, most of which were written by Bruce Allen, who was a general manager of the Commanders. And they were sent to all sorts of people all over the National Football League, including people in the league office, including Jeff Pash, the general counsel. And of the 650,000 emails, only 11 were leaked. And the 11 were written by John Gruden, who, when he wrote them, was not working in the NFL. He was a commentator for Monday Night Football at ESPN, a colleague of mine. And he wrote homophobic, offensive emails about DeMaurice Smith, the National Football League Players Association executive director, and Roger Goodell. Those 11 emails were leaked in October 2021 by someone, we don't know who, anonymously, to the Wall Street Journal and the New York Times over the course of a weekend, and it cost Gruden his job. He was forced to resign by Mark Davis, the owner of the Raiders. And so within just a few weeks, Gruden decides to sue Roger Goodell personally and the National Football League, alleging that they were responsible, the league and Goodell, to purposefully leak these emails to cost him his job and his career. And now fast forward almost 4 years later, finally we had a decision this week by the Nevada Supreme Court. Goodell, as he always does in any kind of case like this, I know we'll get into it, Dan, wanted the case to be decided by an arbitrator, a NFL-friendly arbitrator behind closed doors. There's no discovery. We don't see anything in the public domain about what goes on. A lot of cases have been decided that way. That's the venue of choice for the National Football League. But the Nevada Supreme Court said, no, this time this will be decided in open court by 5-2 vote, a very resounding victory. Gruden is now able to have his day in court, get to the bottom of it, do the truth finding that lawyers do, and that's with discovery, very importantly. And the discovery can include those 650,000 emails, which may have all sorts of other secrets that the National Football League doesn't want out, which is why they wanted this case to be decided by an arbitrator. So that's how we got here. We did a story in 2023, 2 summers ago. My colleague Seth Wickersham and I did an in-depth story on this leaks investigation and matter and how all this happened, the backstory to it. And one of the key facts that gets overlooked, Dan, in that story is we reported that both Roger Goodell and Jeff Pash, the general counsel of the NFL, called Mark Davis, the owner of the Raiders, after the Wall Street Journal leaked that first leaks of racist emails that Gruden had written. They called the Goodell and Pash called Davis and said, your head coach has to go. Why? Because they knew that more leaks were coming. Davis was furious about that. We reported for the first time how angry he was. He blamed Snyder. He blamed Goodell. Gruden coached that Sunday, that next day, and then Monday, lo and behold, the New York Times had more leaks, and some of those leaks were very detrimental and very negative to Roger Goodell. And then finally, Davis forced Gruden to resign. That's a key moment in this case because that's how Gruden and his lawyers came away thinking that Goodell had something to do with this. Why would Goodell know that more leaks were coming? And so this is now, because of the Nevada Supreme Court decision this week, and this will not be behind closed doors with an arbitrator, it'll be an open court. These are the kind of questions that Gruden and his lawyers will try to find out in a Nevada courtroom.
Okay, so Don, you gave us a lot, and I think that background is incredibly helpful. Certainly, as lawyers in our audience, we'll unpack this in the only way that we know how to do, with too much legalese, and this is office hours though, so there's no billable hours, so no worries here. I guess I want to pause on one piece. Yeah, so I guess I guess I have a comment, then I'll kick it to Taryn, who I think has a good question that he's raised. At the end of the day, this is still an open case, right? People are still the headlines. It's always like we have to come here as lawyers and journalists and say, the headline is X, but you have to read the article, you have to read the decision, you have to read the dissent, which I don't know how much time we'll have to get into this with you, but that part's very interesting. So, Taryn, I know you've read the decision as well. I'll let you have the floor. I'll jump back in a minute.
Yeah, Don, you were talking about the actual claims that Gruden made. And just to be clear, the Nevada Supreme Court hasn't weighed in on whether there are merits to those claims, right? Just that this is a procedural thing.
That's exactly right. This is only which venue the plaintiff and the defendant will be able to fight it out. And normally it's an arbitration proceeding, as I said, that's behind closed doors. That's the preference of the National Football League. That's always their venue of choice. Whereas Gruden and his lawyers wanted this to be an open court. And the Nevada Supreme Court decided it will be an open court. But no, there was no decision made by the Nevada Supreme Court on the merits of the case. That's exactly right.
Let's do the boring part first, and then we'll do the broader ramifications. I'm going to say boring part, but it's listen to the Sports Law Podcast. If you're listening to this, you're 100% a nerd for this, so it is what it is. No apologies. When we covered this in the initial instance, there was a really interesting arbitrability dispute about whether someone's comments, and not in their capacity as a coach for the Raiders, could somehow be bound by an arbitration clause that he signed as a coach. So retroactively, things that you've said for the last 10 years, even when you weren't a coach of an NFL team, even when you weren't employed by the NFL, could somehow be funneled through a clause that you had already made those statements. So certainly I've seen clauses like that could say, hey, any disputes pertaining to any statements that you've made in the history of time to the present will funnel through this arbitration clause. But more often than not, arbitration clauses are understood to mean claims that arise during the term. So what first and foremost our listeners should know, and just the general public, the decision that was made by the Nevada State Supreme Court, they were way past this. They've already understood that this could be arbitrated. That even though he was an ESPN broadcaster, they've way past this issue. The issue that was decided on appeal, Don, was listen, again, I don't know who's listening to this. I'm happy to be right, wrong. I know people on the NFL side. I know people on the Gruden side. I'm not 100% certain that I agree with this decision. So for again, for nerd purposes, I guess I don't have to keep qualifying that we're nerds, but it's fine. This was a decision that basically said Gruden, when he signed his Raiders contract, agreed to an arbitration provision. But it wasn't just a normal self-contained arbitration provision. It referred by reference to the NFL Constitution. And the NFL Constitution can be revised and changed in the NFL's sole and absolute discretion whenever they want. So the court viewed this clause, which in sum and substance is found in most NFL executive and coaching contracts, right? That arbitration clause is referenced in the NFL Constitution. What the Nevada State Supreme Court said in a 5-2 decision, that this contract is unconscionable because for a number of reasons. Number one, Goodell's the judge, jury, and executioner, and that clause can be changed at a moment's notice for Goodell. So that's a little bit odd. And number two, that this, I guess this is maybe a secondary part of their decision, but that this arbitration clause they did not view as being revisable, negotiable, because it was referenced in a third party agreement. And in the dissent, which I'm happy I can at least reference that we were talking about the dissent, they said, well, Gruden and his lawyer agreed to the terms of this arbitration clause, even if it referenced a decision, an NFL Constitution as a third party reference. So why wouldn't Gruden be bound by that? So now, Don, we get into this interesting, dichotomy, and I'd love to hear your opinion on the journalist side. This is a decision from the highest state court in Nevada, right? It's not binding on the other state courts, but this is a court saying that fundamentally Goodell's power under an arbitration clause is unconscionable because the party to that contract didn't get to negotiate it, wasn't given a copy of the NFL Constitution, which I'm not sure, again, if I agree with. But even though a grown man with high-powered, representation agreed to it, the court is saying he doesn't have to be bound by that. And I'm just telling you what the court said. I'm not sure that that's the right decision, Don, but I'd love to hear your thoughts here.
Well, first of all, your listeners should know that this was an en-banc group of all 7 justices, right, that heard this. Initially, there were 3 justices that did side with the National Football League, 2-1 a year earlier, and went for the league. And for all the reasons you just stated, Dan, that, when Gruden signed his employment contract to be head coach of the Raiders, he had a duty to know that it referred back to the NFL Constitution, and that, in fact, in doing that, this would be an arbitration proceeding that Goodell would oversee. And so they sided the way you're reading it. It was a little bit of a Hail Mary on the part of the lawyers for Gruden to say, no, we want the full Nevada Supreme Court to hear this. And my understanding from my reporting is it's very rare for when you go from a 2-1 decision that you've lost to then go to a 5-2 decision you win. So all 4 justices who heard this case for the first time sided with Gruden. Now, I can't unpack precisely or, project why they did that, but some of the facts are such that when Gruden sent these emails, he was not part of the National Football League. He was a private citizen. He was a broadcaster at ESPN for Monday Night Football. This was in 2011 when it occurred. And out of a fairness question, Roger Goodell is, in fact, the judge, juror, and executioner in arbitration. And yet he's the defendant in this particular case. And he's alleged to have been the leaker. Now, I know that the lawyers in their arguments before the Nevada Supreme Court and also at the lower court levels and the district court level made these arguments, and lower court judges were persuaded by that. There's something unfair about this, right? It's a tilted system, even though, Dan, I could see your expression, and I know as a lawyer, you're saying, well, wait a minute, there's a clause here, right, in his employment contract, as well as going back to the NFL Constitution. But I think that part of the argument here, can only imagine from what I know and from what the reporting shows, is this really a fair system? Because number one, these emails were not sent while John Gruden was working as the head coach of the Las Vegas Raiders. This was a decade earlier that he sent these emails. And number two, Roger Goodell is the defendant here. And should he be in charge of a system when he's the defendant that is clearly rigged in his favor? So those are the two, I believe, as a reporter, and from what I understand from speaking to legal experts about the case, might have helped persuade the judges, particularly the new judges, all four new judges who unanimously heard it for the first time. The ones who heard it for the first time unanimously sided with John Gruden.
And Don, you mentioned earlier that this clause has been used before, but just to be specific, has it been used in this sort of setting where there's a private citizen, as you mentioned, who is sort of in the NFL sphere, and to punish them for conduct that is occurring outside of an NFL contractual obligation?
No, I don't know of a case. There might be one that I'm unaware of. Obviously, I'm aware of some of the higher profile cases that have gone to arbitration. But all of the ones that I know of, the Ray Rice case, Deflategate, the Bountygate, the really high profile ones. And remember, Bountygate went to an arbitration that Paul Tagliabue, the former commissioner, decided on that, and that punishment of whether Goodell was right or not. That's, Goodell was Tagliabue's protege, and actually was really hard on Goodell in that arbitration ruling. But all of those were all players. They all involved players that were in the National Football League at the time. Tom Brady, the quarterback of the Patriots, and on Deflategate, and Ray Rice, a running back for the Ravens, and the Saints players who were playing, alleged to be part of that Bountygate system. And so, no, that's the outlier here. And the other outlier is, again, and I think this is really important and potentially persuasive when you think about it. Roger Goodell's a defendant. Roger Goodell is alleged in the complaint. When you read John Gruden's complaint, of the person who ordered the leaks. Maybe he wasn't the person that hit the send button to the Wall Street Journal or the New York Times, but he was in the loop of this, allegedly. This is what's alleged, to take out John Gruden. Now, you wonder what the motive is. Well, there were emails where Gruden was quite disparaging about Roger Goodell himself. And so, again, from Gruden's perspective, he's got the motive. He's got the opportunity. And so that's what they're going to try to prove in an open court in Nevada.
Can I jump in quick, Don?
Of course, Dan. Yeah.
So I mentioned the arbitrability piece, I think, is important. As a legal podcast, we have to cover this. And then I think there's the other part that has more broad appeal to just the general public, right? So this is where I think, Don, your coverage of the Lloyd Howell stuff on the NFLPA side and this decision kind of come to a head, which I am particularly curious about. And I haven't really seen that much intertwining of these two pieces, right? So you do mention that some of the emails were about Roger Goodell. Some of the emails that were leaked were also about DeMaurice Smith, and those were put out there. And again, we can, whatever we need to say, right? These are homophobic, these are racist emails, these are inappropriate emails. We're not, that's undisputed.
Absolutely, right? Horrible language. Yeah.
Right.
That Gruden used about D. Smith, no doubt.
Right. And the other part that people should know is, I believe, undisputed. And Don, you are, I think, where I first learned this, right? Beth Wilkinson, as part of her investigation, she's working with the NFL. She gets 600,000 emails. So again, you've alluded to this, but I had a family member who asked me specifics about this case, and I said, do you know how coincidental it is that the only emails that were leaked by John Gruden were emails with employees of the Washington Commanders? It wasn't Gruden's texts on a private, a text message with somebody else. That was the only way they were leaked. And when did the NFL seemingly come into possession of them? Through Beth Wilkinson. It was during the Commanders' investigation.
That's right.
So I don't necessarily subscribe to this theory, but it's certainly out there. People said, well, what would be the NFL's motivation in leaking these emails? So you've alluded to one, that he said bad things about Goodell, so the emails go out. But he also, there were also leaks about DeMaurice Smith and whatever else. The other part that again, I'm not being a tinfoil hat guy. I just want to tell people where theories and where they seem to make sense to me. At this time, when this leak occurred, Dan Snyder had not yet agreed to sell his team. He was completely fighting this back and forth. And you were putting out with Seth some really good stories about the plane and all this thing going back and forth with the Commanders. But at this point, and again, this is not a political podcast, but it's not so dissimilar that what's happening with President Trump right now with respect to a certain list being released. And then there are certain theories being released that President Trump is talking about other people to get the pressure off himself. So again, not a political podcast, but those are the theories out there. So the theory that I think is the most pervasive on social media, wherever else, is that Dan Snyder, maybe with, maybe in conjunction with the NFL or otherwise, was behind these leaks in some way, shape, or form to get the pressure off of Snyder and onto any other controversy. And say what you want about Snyder, I'm not aware of emails that Snyder has sent to this effect. So we're not here to say what's worse or what's not. But certainly it would be plausible to think, if you were Dan Snyder or someone working at the direction of Dan Snyder, that, hey, these emails are worse than anything I have done, and therefore this will get the attention off me. Don, I know you don't know the answer to this, but what do you say about this theory? Because I think this theory is where Gruden is going to go in this case. He's going to dive directly into this issue. And I find that to be the most fascinating part about what we look at moving forward.
Well, Dan, it's not just a theory. So the story that I did with Seth Wickersham in the summer of 2023, it's an in-depth story. I would encourage your listeners to find it. It's basically, the headline is, how the Gruden leaks led to the ouster or the end of Dan Snyder being an owner of the Commanders. And there is reporting that Seth and I found that Snyder, who had access to all these emails, remember, there was a shared agreement of all of the evidence between Snyder's lawyers and the NFL. Even though Snyder was the target of the investigation by Beth Wilkinson, all of the discovery behind closed doors that Wilkinson was doing was shared with Snyder's lawyers. And we have reporting that shows that a motive, if Snyder had leaked them or had been part of some of the leaks, was for him to absolutely what you just said is true, to kind of get the spotlight off of him. He was, targeted with all these workplace culture allegations and sexual harassment allegations directly against him, that he would have had that motive to release it to sort of get the spotlight off of him. Also, we had reporting that he also could have done it to ingratiate himself with Goodell. He was in trouble with Roger Goodell. He knew that these emails were Gruden saying horrible things about Goodell. There is reporting that we had in that story we did a couple of years ago that Gruden and Goodell never liked each other. There's some fascinating stuff in the story about that. Snyder knew that, and so he might have been partially responsible. Goodell could have known it, but yes, it might have been Dan Snyder. A lot of people had access to these emails, a lot of law firms, lawyers, people in the league office. And what's so fascinating about this story is a lot of people had motives to do it. And so it wasn't just Roger Goodell. I'm glad you raised that. Snyder also clearly had motives here. Another person that could have had motives is a woman named Desiree Perez. She works at Rock Nation. That's the Jay-Z firm that for $5 million a year does social messaging for the NFL. They also help pick the halftime show at the Super Bowl every year. Desiree Perez is somebody we had some reporting also suggesting that she was in the loop on these leaks. She denied it. Got to be very clear. Goodell has denied it. Snyder's people have denied it. Rock Nation's denied it. We even had some reporting that DeMaurice Smith might have been responsible for the leak to the Wall Street Journal because his job was on the line. And so, I mean, that's, again, this is really like this fascinating story, this moment in time. And I want to emphasize something. You said it before. There were 650,000 emails. The only emails that were leaked were John Gruden's emails to Bruce Allen. And let me be clear who Bruce Allen is. Bruce Allen was the general manager of the Commanders. He went way back with Gruden. They're very, very good friends, very close friends. And so they're talking the way you do with a close friend when you don't think anybody's listening. I'm not excusing what they said, but that's why that language was there. But guess what? Bruce Allen is friends with lots of other people, including people in the league office, like Jeff Pash, right?
Let's pause. This is what I think is the most interesting part. So we could talk about who the leaker was and whatever else. You said something very important that Bruce Allen and John Gruden were talking amongst friends, whatever we want to say, locker room talk or whatever euphemism we need to say. What are the chances that there are no other friendly communications that occurred in all of Washington HQ? It's almost impossible. So, we can mention the names of who the leakers are. The amount of people that might have also said offensive things in that 600,000, it's more than John Gruden. It's more than Bruce Allen. It's almost impossible. And then we have to go to the next level. And I told you, Don, I would try to tie this in, and we found a logical spot here. So I remember you reporting that DeMaurice Smith was on his way out, and we in the crystal ball. Obviously he ends up on his way out. Lloyd Howell ends up in. There's some obviously a couple years that pass in the middle. Here's where I think if we're lawyers and we're trying to figure out what is quote unquote discoverable, if I'm Gruden, I'm fighting for the release of those 600,000 emails. Period. Hard stop. I think if you're the NFL, you have a really hard time, and I know Taryn is going to ask about exception moving forward. You have a really hard time not admitting those. I don't know what argument you'd have that the rest of those aren't applicable, because it's very clear, at least to me, that those emails came from that set of documents. Now, where I would like people to at least pay attention to is that Gruden can ask for the moon, right? Like you aim for the stars and you land on the moon. Gruden is going to ask for every single email that the NFL possesses that includes some of those terms, right? Homophobic terms, racist terms, misogynistic terms, whatever you want to say. He's entitled to ask for it because what he is alleging is very specific. And again, is he going to get it? I'm unsure, but this is what he's going to ask for. Hey, you were in possession, the NFL, of these emails that made me look bad that touched on these categories: homophobia, misogynistic, and racism emails. Okay. I want any other email by any other, coach, this one that's in your possession right now, in any of those categories, and I want to figure out why those weren't leaked. So there's going to be 100 protective orders, non-disclosure agreements, confidentiality agreements. But Gruden is a loaded gun. He doesn't work for the NFL anymore. He's probably never going to coach in the National Football League ever again. And I think he has a colorable lane to basically ask in a legal forum that's not controlled by Roger Goodell, that's not arbitration, that's controlled by judges, for every skeleton that the NFL has in their closet that they've chosen not to release. And Don, that, and again, just to tie these two things together, right? You had a story about Lloyd Howell, about this decision about collusion on quarterback guarantees. What else could be out there that the NFL has chosen to bury? And that's, I think, the most troubling aspect if you're the NFL, that it's not just that he can ask for it, it's that you as Goodell are no longer the judge, jury, and executioner. You can't kill those requests. And now they're just open to a third party's subject of reasonableness, whether they should be discoverable. So if I'm the NFL, I'm not just nervous that my arbitration clause has been destroyed forever. That's a given. I'm really nervous about John Gruden, who's holding a match, and NFL HQ is doused in gasoline right now. That's what I would be terrified of.
Yeah, and I believe they are. The reporting that I've done this week indicates there is major concern around the league about this, for all the reasons you just stated, Dan. There's a lot of danger to the National Football League. Their deepest, darkest secrets could be open to discovery in an open court. And this is an area that the league is not used to living in. They're used to having all these cases decided by an arbitrator, by a league-friendly arbitrator. And, there was just to rewind to the Dan Snyder case, for instance, I reported that Dan Snyder's partners, one of them was Fred Smith, who just passed away. He was the chairman of FedEx and the founder. They were alleging that Dan Snyder was using money that was partially belonged to them. They owned 40% of the team, and that Snyder was using all sorts of team money for personal expenses. And there was an arbitration, and it was behind closed doors. And guess what? Goodell killed it. You can look up the story. It didn't get out of the batter's box. And so that's how a lot of these arbitration things are done. They're secretive. I mean, I happened to get the arbitration document, so I was able to write about it in a lot of detail, but that's how these cases go. And so this is completely uncharted waters, which is why there's been a lot of speculation this week. And I think it's right that there's no way there's ever going to be any discovery, because the National Football League is going to back up the Brinks truck and offer a massive settlement to Gruden and to his lawyers. Here's the problem with that. 2 years ago in our story, Gruden said he doesn't care about money. He's not motivated by money here. He's motivated only by the truth. He's willing, and this is a quote from him, burn the house down to get to the bottom of this. That kind of incendiary language by somebody he's worth, tens of millions of dollars.
I like your use of incendiary there.
Right. It's incendiary language. Exactly. Literally. And to have somebody like that who's worth, I don't know how much John Gruden's worth. He's worth a lot of money. He made a lot of money as a head coach. He made a lot of money from ESPN as the Monday Night Football color commentator for years. He's now working at Barstool. He's got income there. He's motivated by the truth. He is extremely angry at Goodell. They had a bad history going way back. And again, we lay that out in the story we did 2 years ago for anybody who's interested to go and check that story out. And now it's like, this is the guy he believes who cost him his career. There was a line by Brent Musburger, the great, CBS broadcaster, when this leaks first happened. He went on radio in Las Vegas and he said, whoever leaked these things against Gruden, this was a professional hit. That's the language that Musburger used. He said, this is somebody who was a paid assassin to take Gruden out. Because as he put it, these were not leaks to somebody like an NFL insider, like my colleague and friend Adam Schefter. This went to the Wall Street Journal, and then 2-3 days later, the New York Times. And as he put it, this is not the usual NFL leak. This is somebody else. And again, Gruden believes it's Goodell. There's other reporting that points to Snyder. There's other reporting that points to some other people. But from Musburger's point of view, it's like, look at the way this guy was taken out. And not only did he lose his job, he lost his career. And look, he wants to coach again. He said he may want to, John Gruden said he may want to coach college football. But I'd be very, very surprised if he ever coaches again in the National Football League.
Yeah. And so, Don, we appreciate your time. And just one last question. I think just looking forward, you mentioned possible Supreme Court challenge, but as Dan was talking about, this ruling isn't binding on anyone else, any other jurisdiction. So do you think that is there any way that the NFL can find a number that does make Gruden at least stop and take pause and put the match down?
Everybody has a number, right? And the National Football League is not only the most popular sport in America, it's the wealthiest exponentially. And so when we saw the case of the Rams leaving St. Louis and going to Los Angeles, there was a massive settlement for the city of St. Louis in that lawsuit to the tune of $850 million. And most of that money had to be paid by the Rams owner, Stan Kroenke. So now the question that's really interesting is, let's say it's $100 million. Let's say that's the number that Gruden would accept, his lawyers would accept. Are the owners going to be pleased about paying that? Or are they going to say, wait a minute, we believe Roger might have had something to do with this, or Snyder had something to do with this. Why should we have to dig into our pockets and split 100 million 32 ways? That's $3 million each when somebody else was responsible for this. That's a kind of interesting question that I've got my eye on that ball too. And, owners, we reported 2 years ago that 4 owners on background talked to Seth Wickersham and I and told us that the owners believe that Roger Goodell was behind the leagues. So there's a lot of bad blood around the league over this issue. For lots of reasons, as we've expressed here. I mean, it's a bad precedent, right? The arbitration, as you said, Dan, quite correctly, has now been blown up. The arbitration that they've relied on for so long in so many of these very dicey cases and tricky cases. There's a lot of money at stake, and there's also a lot of secrets that are hanging in the balance that the NFL does not want anybody to know about. So there's very, very high stakes here, and it's going to be very interesting to see how it plays out in the coming weeks and months.
Last thing, then we're going to get you out because we know you're working on something, which we don't know what it is, but you have important stuff to do. Taryn has alluded to this, and this is what the last thing to leave everybody with, right? Okay, so the Discovery could pull things out that's really, that's very, about other owners, very salacious, whatever. From a legal perspective, and this is a podcast that we covered the Ram stuff very closely. What I want to just give you and our listeners the heads up on, in the not so distant past, about 2021, the NCAA lost a very big decision in a Ninth Circuit Court of Appeals. They lost, and this was the very famous NCAA versus Alston case, which led to the NIL era that we're now in. They lost, and it wasn't that big of a deal to lose, right? It's not really binding on the rest of the country. It's a Ninth Circuit Court of Appeals decision. It's not binding on the rest of the world. Right now, you have a really bad decision from the Nevada State Supreme Court, which really only matters to the Raiders. Doesn't really matter to anybody else. If they take this decision and appeal to the United States Supreme Court and they lose again, Taryn, pop quiz. Who is it binding on?
Everyone.
The entire NFL. So
Yeah.
people are asking, will they appeal? Will they want to appeal? I'm like, well, they should at least consider it. But if they lose that, this arbitration decision about the enforceability of Roger Goodell's arbitration clause seemingly is void across the entire country. So you lose a lot more. Imagine all the little battles that we don't know about that are just swept under the rug through arbitration. That's the fear. So if I had to guess, I would think there's a lot more to lose by appealing this to the United States Supreme Court. A lot could go wrong that goes far beyond the corners of this John Gruden case. And that's the decision that's being weighed. Certainly, we're going to find out. It's going to be public if they appeal this to the United States Supreme Court. But while we're getting very excited about it, that's a tremendous, tremendous gamble that I'd be very surprised if they took lightly.
Yeah, well, we know, and we reported on Tuesday of this week, that the first step that the National Football League took is to ask for the Nevada Supreme Court to rehear it. Now, I'll be stunned if they do that, right? This was arguments were almost a year ago. It was a 5-2 decision. It was not 4-3. Like I said, all 4 justices who heard it for the first time sided with John Gruden. I'll be very, very surprised if they do that. But that might have been a way of buying time, Dan, to your point, that this far more serious question, and it's a massive gamble, right, to go to the United States Supreme Court if you lose. Now, the league may be so fearful, though, of those secrets that it's a gamble that they're going to say is worth taking. And that's what's so interesting about this, is that, their backs are up against the wall in a way we're not used to seeing the National Football League ever be in. As I say, I keep using the uncharted waters. All of these really tricky cases, they go to arbitration. And we don't know anything that happens about it unless we get a leak or two. And I've been lucky enough to get a couple of them, and some other reporters have too. But for the most part, we never find out what happens in any of these cases. But this one, which is particularly difficult for the league for all the reasons we've expressed, is now they're now facing the decision. Okay, are we going to roll the dice with the United States Supreme Court? And if we lose, this blowing up of the arbitration rule, all 50 states it gets covered by, or are we going to take our chances and hope that a friendly court, and maybe they see the United States Supreme Court as friendly when it comes to arbitration decisions, right? For employers, there's a history there, as I understand it too, and maybe you guys would know more about that. But that's what they're going to have to weigh, and they're going to have to make that decision relatively quickly. Like sometime this fall, that decision will be made by the NFL.
I'm only smiling because we could hold you hostage here for another half an hour and have this fun conversation, but we know you have stuff to do. Don, you're a wealth of knowledge as always, and you're one of our favorite guests coming on. So certainly appreciate your time.
Thank you, Dan. Always great to be with you, and the rest of you guys. Thanks so much.